To talk more about Julius Malema's pre-sentencing, we're joined by legal analyst Mpumelelo Zikalala. Mpumelelo, good evening. Thank you so much for your time. Really do appreciate it. Can you walk us through how sentencing, pre-sentencing proceedings take place and what the objectives are?
Good evening to you and also to your viewers. It's like the second part of the trial. Remember that determining whether the person is guilty or not has been determined now. You've proved that they're guilty. Now you're trying to find the appropriate sentence. Hence, evidence is going to be led from both parties, which is the prosecution and the defense, to say, with the prosecution is saying we want the highest sentence possible, the defense saying that we want the lowest sentencing possible. Now, what the court would use is a system which was developed in the case of S versus Zin. So they would say, let's look at the crime. Is it legislated? Yes, it is. Does it provide a minimum sentence? Yes, it does. Can you make submissions which are going to deviate from the minimum sentence? Remember, minimum sentence that says if you are guilty of a certain particular crime, this is the minimum sentence in which you are going to start with going up. If you want us to go below that particular threshold, then you must be able to convince us. And then it says the second part, let's look at the actual victim, or let's look at the actual accused individuals and their personal circumstances. How old are they? Are they feeding a family? What's the impact in terms of their standing in society? So all those things will be considered. And then the last one will be the interest of society, to say, what type of message do you want to send as the court to the other individuals that may be tempted to break a similar law? Can you send a warning shot to them to say, look at what happened to this individual. If you engage in a process which is like this one, this is the type of sentence which is going to. The most important one in this case, though, I think, will be the one of determining, is it a custodial sentence? Do you send Mr. Malema to jail? Or do you say to him, here's a suspended sentence, here's another alternative of punishment, let's take it from there?
Yeah, so there's minimum sentencing and at least minimum prescribed sentencing, and then there is a likely sentence. Now, of course, the person that has been found guilty and the defense there would try to argue for a judge to go lower than the minimum required sentencing. And you mentioned some of those prerequisites that they'd have to meet in order to make that argument stand. But how far below the minimum sentence can a judge deviate?
Well, it depends on the discretion of the judge, but most importantly, other case law that has been there. So if the minimum sentence, for example, is 15 years, going lower and saying that a person must go and spend 2 years, you must find really exceptional circumstances which are going to be able to prove that. So you can go low, but not as low to such an extent that it makes the process of sentencing meaningless or not to fit the objective of why the legislation was created. Remember, in this case, it's not as if you are dealing with a common law crime. You are dealing with a crime or an offense which is legislated. So there's legislation which must guide you as to what type of sentence that they must be. Let's also remember, when it comes to sentencing, I can give you a sentence of, let's say, 5 years, but then suspend it. So you don't have to serve the custodial sentence or go to jail. You can still receive a sentence, but serve it in another form or manner.
Yeah, and under what circumstances does a judge consider suspending a sentence? Is that discretionary, or are there guidelines towards that? And of course, is there an instance where if the minimum prescribed sentence does not make room for a suspension of that sentence, can a judge still consider that?
It would depend on the type of forum in which they're in. If we're in the magistrate court, we're sort of confined. If we're in the high court, you do have inherent jurisdictions, so you can go below the minimum sentence. But the most important part is, can you be able to substantiate why you want to go below the minimum sentence? The other part of it is this one. Do not kill a fly using a sledgehammer. At the end of the day, the sentence must be appropriate to the offense that has taken place. Yes, there was a gun that was discharged, but no one died. Yes, it was in a context where it was in a public area, but let's also look at, was it done towards the direction of the individuals or the members of the public? Was it done in a separate area? So if true concern was then taken into consideration as to the safety of individuals, that must be taken into consideration. You simply can't ignore it or engage in a meal process where you simply say, this is the minimum sentence, this is the offense that's taking place, this is the type of a sentence in which I'm going to mint out. Which is why, again, these pre-sentencing proceedings are important, because that's where all these witnesses would come in. That's where all the other government officials which are in charge in looking at the circumstances of the individuals, the social workers, for example, will come into play, provide evidence in order to assist the court to come to the appropriate sentence.
Yeah, and let's talk about Julius Malema for a second. There's a lot at stake for him here. In fact, there's a threshold within which, if his sentence above the threshold, would be that would certainly be a serious limitation to his political career, particularly as someone who wants to run for public office and or be a legislator. He currently is, and of course, there would be consideration to what the sentence has on that. Talk to us about what's at stake here.
There's a lot for him. Let's take the current political term. It means that you can't go and participate in parliament, he will be in jail. Even after the sentence has been done and dusted, and when he wants to come back, remember that clause that prevented the former president, Mr. Jacob Zuma, from going back to parliament will still apply to him. So it basically going to mean he's going to be out of the political game in terms of playing an active role within government for some time. Hence why I think he's going to fight tooth and nail to make sure that at least what he can get in this type of sentences is going to be a suspended one. Even after it has been suspended, it should be very liquid so that he's able to go back and contest in parliament as the leader of the EFF. So for him, I think he's going to want to make sure to say, don't focus on me as a political individual only, but look at all the circumstances that are here and let's take it from there. But he has made it known that at the end of the day, no matter what type of sentence which is going to be meted out, he's still going to appeal, and when he appeals, he'll appeal both on the merit and on the sentence. So this is just step one of the many steps which are yet to follow.
So even if it gets 5 years or 15 years, if it's suspended, his political career survives?
If it's suspended, yes, but I stand to be corrected in terms of the amount of time that the specific legislation is for the Constitution prescribed. I think it's a year or 2 years, but it does prescribe a certain amount of time in which must be, the threshold mustn't go above. So if it does go above, then it means, politically speaking, he will be out of the game for a number of years.